Now let's get into what we're here for today. We're going to talk about the Dram Shop Act and what happens when people get drunk and accidents occur. The whole concept of the Dram Shop law is that an entity can be responsible if somebody gets drunk and causes injury or death to another person as a result of being drunk, as a result of intoxication. And if you can prove several things that we'll talk about today, that the person was intoxicated, that they cause accident, injury, death, property damage, any kind of damage or injury to others, then under certain circumstances, a third party, being the person or entity that provided the alcohol to that tortfeasor, can be held liable. Now, there's generally two different scenarios that you're always going to want to think about, and there's two statutes we'll talk about that apply to those scenarios. One scenario is in a commercial sale of alcohol. So we're talking about a bar, a restaurant, any place where there's an exchange of money, where in return alcohol is sold. And by liquor, we mean anything with alcohol content. It doesn't have to be a spirit like a bourbon or a vodka. It could be a wine, it could be a beer, it could be wine coolers, anything with alcohol content that is sold for money. And then that gets into the system of the tortfeasor who becomes intoxicated and causes injury. So that's commercial sale. And that is one scenario. The second scenario is where it's not a commercial sale, it's not a bar or restaurant, and there's no exchange of money per se, but it's where the scenario is someone's having a house party, right? We always talk about this, especially all of us lawyers with kids that may or may not be of drinking age. This is where that comes into play. Kids are all drinking in a house, they're underage, someone gets drunk and goes and causes an accident. Who's liable? Who provided and furnished them the alcohol? It doesn't have to be for a sale. Another scenario that doesn't involve commercial sale would be if, I know I did this when I was a teenager. We hang out, maybe we're 17 or whatever. Dad, I don't know if you're listening, but you probably wouldn't be surprised. And we like hang out outside the supermarket or New York City, the bodega or liquor store. And we'd ask somebody, would you mind running in and buying us, a 6-pack of wine coolers or beer or whatever? Back in my day where I grew up in New Rochelle, we used to get 40 ounces for those of you who remember those, malt liquor and all that, Old English. So if you ask somebody to get you alcohol, they go into the store, they buy it, give it to you, and then you cause injury or a friend or whoever who's intoxicated from that, then there can be liability against that nice person who thought they were helping out some teenagers by getting them alcohol. All right. So there's generally these two scenarios, and sometimes they overlap. Sometimes they're completely separate, but generally that's what you're going to see. And we're going to talk about these two scenarios and how they play out. Lastly, just as part of this overview, is that an intoxicated person cannot recover from someone that either provided them alcohol or sold them alcohol if they cause their own injury. So if I go to a bar, I get slammed drunk, I'm sitting there, I say, yeah, I'm visibly drunk, keep serving me, keep serving me. They keep serving me, I keep drinking, I get in a car, I go off the road and crash into a tree and get injured or killed. If I'm alive, me, if I'm not alive, my family does not have that cause of action, okay? You do not have a cause of action for injuries you sustain. You can't say, I shouldn't have been served. I know I bought the alcohol, whatever it is. So keep that in mind. And also, if you as the injured party participated in the procuring of the alcohol, either in getting it, buying it, but if somehow you are actively taking steps to get the alcohol, even if you're not drinking it. You're the one that asked the person to go into the store. You're sitting at a bar with your friends, and your good friend is buying rounds and rounds, and you pass them over some money to help pay for some drinks. You're out of luck. So you really have to be with clean hands and not be the one who was involved in procuring or getting the alcohol or being the one that causes the accident. Then you're not going to be able to avail yourself of the Dram Shop Act. So generally how these cases will come across our desks as lawyers would be a scenario where some friends are out drinking, they get in a car, or even one person is out drinking, gets in a car, goes and causes a horrific car accident. A bystander driving a car gets injured or killed, and then it turns out that the vehicle that struck them may or may not have sufficient coverage. But then you find out that the vehicle that struck them, that the driver was intoxicated. Maybe they get cited on the scene. You see that in the police report. You hear about that in your investigation. That's when you want to say, okay, the person, there's no doubt they were intoxicated. There's no doubt they caused this accident. Is there perhaps some liquor liability, dram shop liability? Where did this person drink? So you want to see, sometimes you can't find out the answer to that. Sometimes the only person who knows is the person who caused the accident, and they may not be willing to share that information. They may not be alive. They may have died in the accident. So you're going to want to try and find out where they were when they got intoxicated and what the circumstances were. When you get all those facts, and when you apply the law that we're going to discuss to those facts, then you'll see whether or not you have a viable case. All right. So there are 3 statutes that you need to know, and they're in your materials, that govern this area of liquor liability. The first, sort of the bedrock of it all, is called New York Alcohol and Beverage Container Law, Section 65. May not be container, it's Beverage CONT Law, Section 65. And that is in your materials. And I'm going to share my screen. You all know I don't like to share screens too much, but I'm going to share it with you because what this law does, this provides the definition of an illegal sale of alcohol. And based on this, we're then going to go to the general obligation laws that give you the right to bring a lawsuit if alcohol was illegally sold. This statute says what an illegal sale is. That's why it's so important that we all know Rule 65. So I'm going to share my screen if I'm allowed to do this. And here we go. All right. So right now we're looking at the beverage law section 65. Obviously, you're going to want to read the whole thing, but here's the important part that I highlighted. It's an illegal sale if a person sells, delivers, gives away, allows to be sold or delivered, all this preamble, and then the highlighted part. So there's really 3 categories that result in illegal sale. One is any person who's actually or apparently under the age of 21 years. Now, we're going to be talking about that phrase actually or apparently because it creates some problems. But basically serving somebody underage, that's an illegal sale. Giving alcohol to someone underage is illegal. 2, any visibly intoxicated person. This is a harder one to prove, but if someone is drunk, clearly objectively intoxicated at a bar, and someone still continues to serve them alcohol, that is illegal. And then lastly, a category that you may not see a lot of, but it's an interesting one. It's any habitual drunkard known to be such to the person authorized to dispense alcoholic beverages. All right, so basically, if we all know that Jane from around the corner, she's just a drunk and she comes to the bar every day and everybody knows her, everybody knows she's a drunk and she's sitting at the bar. If you serve that habitual drunkard and you can prove with evidence that she was a habitual drunkard and then caused the accident, then the plaintiff would have the ability to say it was an illegal sale. All right. So illegal sale to a minor, to someone visibly intoxicated, to a habitual drunkard. These cases that we're going to come across as attorneys are usually going to be one or two. It's going to be the illegal sale to a minor or visibly intoxicated. Now, as far as the burden of proof and proving the facts, it's going to be much easier to prove that someone was actually or apparently under 21. You get their information and discovery. You find out if they're under 21 years of age. You find out if they got into a place. Did they show a fake ID? Did they not? Were they asked for ID? Were they sold? That's going to be the clearest one to prove. So when you're looking at these cases, when they come across your desk at the outset on the plaintiff or defense side, and you say, oh, they're citing to the liquor law, the general obligations laws that we're going to go through in a moment in their complaint. Let's see, what's the cause? Was it a minor? Well, what do we know? Were they underage or not? And then the second one, the visibly intoxicated, that's going to be tricky, right? Because some people who are drunk hide it well. Some very easy to see they're drunk, but then it becomes more subjective, right? It's not always as easily shown objective unless they're really, there's video showing them stumbling or muttering their words. If not that, then you're going to need witnesses. You're going to need someone who's going to come in and at least raise an issue of fact that, oh, I saw that person and they were hammered and they kept serving them. Or on the contrary, I saw that person, they looked perfectly fine. There was no reason to think they were intoxicated. All right. And also that gets into the factual issues of how much do they drink at that given location, right? Maybe the person was drunk from a prior place, came to this bar, only ordered one drink, but was already hammered. The bartender may say they didn't look hammered. I just served them one drink. That may be one fact pattern. Or the bartender may say, yeah, I served them 6 drinks, but they didn't really seem impaired to me. I think they were able to hold their alcohol well. They weren't visibly intoxicated. So the facts are really going to move where these cases go. And it's going to be really important for both sides, plaintiff and defense, to get an investigation going immediately when you think there's a case here.
If you're joining us today via podcast, the first attendance verification code is DRM055. Again, DRM055.
So a couple of things. First of all, thank you, John Fazzini. I had a memory moment. It's New York Alcohol and Beverage Control Law, not container. Control is the CONT. So thank you for that. That section 65 is from the Beverage Control Law. So as far as the investigation, several things. First of all, on point with what you just heard from my partner, Rosa, who does coverage work, is you're going to want to demand coverage information because, believe it or not, there is not always coverage from entities for liquor liability. It is a separate policy. It's not usually part of a general liability policy. So even if you're the owner of a premise, you are not covered if someone has a party there and sues alcohol for liquor liability. So I strongly encourage those of you on the defense side or who do carrier work or represent restaurants, retail, places that have a license or not and serve, want to make sure that they have a liquor liability policy, because we've run into situations where we may have a dram shop case, but it looks like there's no coverage, which would be pretty bad. And most of these businesses can close up shop and reopen under another name. It's not like going after an individual. There's not that much of a threat. So you're going to want to look into coverage. Now, as far as investigation, when you first come across a case involving liquor liability, couple of things you need to get the answer to as soon as you can. First of all, you want to find out, is there video of the bar? A lot of bars have video now. They have it over the teller machine. They want to make sure their bartenders are being honest. They want to have it for security purposes, for all kinds of reasons. So immediately demand and send preservation letters for any video. Some places like nightclubs or popular evening spots will often have cameras at the front door as well, maybe where IDs are being checked. So you're going to want to get video footage for sure. You're going to want to find out about witnesses and get to them and question them about what they observed, whether they observed this person who was the tortfeasor being served. Did they appear intoxicated? Do you know what they were drinking? How much? You would also want to send a preservation letter for the tab, for who paid for this. You're going to want to see, was it cash? Was it paid with a credit card? Can you get receipts? Can you see what was actually purchased? What the tortfeasor drank? Did the tortfeasor pay for it on their own? Did someone else pay for it? All that type of stuff. So witnesses, locations, video, those are all super important. Coverage, you're going to want to do all of that right away, because and ultimately you'll dig through all of that in discovery, which I'll talk about in a moment. But early investigations is important. Now, I've been asked about some cases whether to look into a dram shop matter or not, and usually if the injury, in my perspective as a plaintiff's lawyer, unless there's a serious injury, and there's just no coverage from the tortfeasor, these cases can be complex and they can have motion practice and lots of depositions and lots of investigation. So in a case where the value of the case may be very low, on a good day, you may not be worth the expense of getting involved in a dram shop case. That'll be for you to decide. But again, you want to do your homework and find out as much as you can about the facts and how strong or weak the case is, what the coverage is, and relay that to the injuries in your situation. All right, now we're going to look at the two statutes in New York State that govern this area of law that you will have to plead in your complaint. And these two statutes are what apply to commercial sale and non-sale, the furnishing that we spoke about. So think of one of them will deal with the typical bar service scenario. The other will deal with the house party scenario. All right. So the first one we're going to look at is General Obligations Law 11-101. Again, these are all in your materials, but I just want to go over this. I'm going to share my screen again on this so that we're on the same page. So right now you're seeing General Obligations Law 11-101. This is the actual Dram Shop Act. This is it. The Dram Shop Act actually started back in the 1800s in New York State. And it was tied into a Civil Rights Act, and it developed over time, whereas in modern times, it has now been known as General Obligations Law 11-101. And as you can see in the title, it says compensation for injury caused by the illegal sale of intoxicating liquor. Illegal sale, right? So this is commercial sale. We're talking about money being exchanged, and we're talking about it being illegal. So you have to look at Section 65 of the Alcohol and Beverage Control Act to see if it was an illegal sale. So here's the language. I have it highlighted. Any person who shall be injured in person, property, means of support, or otherwise by an intoxicated person, or by reason of the intoxication of any person, whether resulting in death or not, shall have a right of action against any person who shall by unlawful selling to or unlawfully assisting in procuring liquor for such intoxicated person, that means you're the one who's buying it at the bar and giving it to somebody, have caused or contributed to such intoxication. And in such action, such person shall have a right to recover actual and exemplary damages. Actual is compensatory, exemplary is punitive. All right. So this is super important, because if you can make out your case that there was an illegal sale, that it got somebody intoxicated, and that intoxicated person caused death, injury, damage to property, or otherwise to someone else, that someone else or their family can recover compensatory damages as well as punitive. Again, this statute is meant to put the burden on these retail establishments. It's in the public interest, that places that are granted a liquor license do not sell alcohol legally, that they don't sell it to young people, that they don't sell it to people who are drunk, because it's foreseeable someone could leave the bar drunk and cause an accident. So it's meant to be punitive. That's why there's the exemplary damages section in there. All right. So this is General Obligations Law, section 11-101. This is what you're going to plead. This is going to be the basis of your case. If you can prove an illegal sale under Rule 65, this is what will hold those retail commercial establishments responsible if you could make out your prima facie case as a matter of law, and they will have to pay compensatory and exemplary damages. Now let's compare this. Next, we're going to look at GOL section 11-100. So there's just a difference of one number. The first one is GOL 11-101. That is the commercial. Now we're looking at 11-100. Now we are looking at General Obligations Law 11-100. Now, the start of it is the similar, the highlighted part. It's any person who shall be injured in person, property, means of support, or otherwise by reason of the intoxication or impairment, right? They're not talking about sale or illegal sale. That's not in this statute. That's why this is the furnishing. There shall have a right of action, I'm reading the highlighted part now, to recover actual damages, not exemplary, right? This is not penal in nature, actual damages or compensatory damages against any person who knowingly causes such intoxication or impairment of ability by unlawfully furnishing to or unlawfully assisting and procuring alcoholic beverages for such person with knowledge or reasonable cause to believe that such person was under the age of 21 years. All right. So this statute, it's not all three categories like 11-101 and Rule 65, Section 65 of illegal sale, because this statute has nothing to do with sale. This is a statute you're going to bring into play if you believe someone got intoxicated through someone else furnishing it to them without it being a sale, right? At a private home, perhaps, or that person who runs into the Quickie Mart and buys a six-pack for a bunch of teenagers. That's what this is going to apply to. But here's the kicker. There is no penal part of this, right? So there's no exemplary, and a real key part, which I'm going to get into, is that they have to have knowledge or reasonable cause to believe that the person is underage, right? So again, that's going to be fact-based. If your kids are seniors in college and they and all their friends are 21, and you asked your child, listen, I know you're having 6 friends over tonight. Are they all of age? Is there going to be alcohol? And your child who you trust says to you, yeah, they're all 21. No one's going to be drinking who's not 21, and no one's going to be over who's underage. So you don't have to worry about anything. They're very responsible young people. The parents leave. The kids get hammered drunk. Turns out someone's 20. They go back. They cause an accident. The homeowner gets sued for allowing somebody under the age of 21 to get intoxicated at their home. But here, the defense, if you're defending it, is going to be the testimony of the parents saying, I thought everybody was 21. If I knew anybody under 21 was there, I certainly wouldn't have allowed it. And then, of course, that would be open in depositions to test that. Oh, really? Did you consider the fact that your friends, not everybody who's a senior in college is 21? You can work with it. But again, the key that you'll be focusing on is whether or not in a situation of furnishing alcohol, the person who furnished it had knowledge or reasonable cause to believe they were underage, right? So in the scenario I gave where that person outside of the Quickie Mart, there's a bunch of kids hanging out and they run up to him and they're like, hey man, can you go buy us a 6-pack? Here's $20, keep the change. That person should have reasonable cause to believe that they're underage, because otherwise they'd go in and buy it themselves, right? So that's how you would establish that. So that's where this statute comes into play, GOL 11-100. So here's where we're going to get into some tricky stuff on how these two interact with each other. Now, we've all heard, or many of us have heard, well, what about strict liability? isn't 11-101 strict liability. And there's a lot of case law out there that says it is strict liability. And I personally believe it is strict liability. That under general obligations 11-101, if you remember the phrase actually or apparently under the age of 21, that means if you are a retail establishment and you have a liquor license, you're selling alcohol and you sell it to somebody who's is under 21, or you don't know they're under 21, but you serve it to them and they are actually under 21, hence actually or apparently, you should be strictly liable. And this is an argument that I've made all the way up to almost the Court of Appeals. Now, surprisingly, the law I've checked hasn't changed since this case I'm going to talk to you about. That's not the deal. It is not strict liability, despite other cases saying so in the state of New York, according to the First Department Appellate Division. I'm going to tell you a fact scenario of a case and what happened and let you all see some of the pitfalls of this. So here's the scenario. Here's a fact pattern. My client's name is Matthew Ferber. Matthew goes out with three other friends, another guy, two girls, two guys, two girls. They go out to do some drinking. They start off at one bar, and that first bar is called Old Erie Tavern. They go to that bar, they have some beers, maybe some shots. They say, all right, let's bail, let's go to another place. They drive to another bar, and that's called Hacienda. It's a Mexican restaurant. Let's go there, maybe have a bite to eat. They go there, they sit at the bar, they order some food, they order some beers. Then from there, they decide to end the night at a bowling alley, GW Tavern and Bowling Alley, and they go there and finish the night with some cocktails. It's now pretty late. It's like midnight. They were all underage, okay? All underage, all 20, I believe. And they have fake IDs. So they get in the car and they start driving down the highway, and the driver of the car, named John Baylor Jr., was drunk, was going over 100 miles an hour, and it's every parent's worst nightmare, four drunk people in a car. He crashes into the guardrail, and it's a horrific crash. Guardrail pierces through the car. The driver is killed. The young man is killed. My client is seated behind the driver, and he gets impaled with the guardrail, and he loses his legs and gets ejected out of the car. And then you have the co-passenger in the front and the rear right passenger, and they both pretty much escaped relatively unscathed in the scheme of things. So that's the fact pattern. Now, we bring a lawsuit, which is in your materials. This took place a little north of the city in Orange County. And we bring a lawsuit against the estate of the young man who was driving for negligence, as well as his father, who is the registered owner of the vehicle. That's the easy part of the case, right? The owner of a vehicle who's given permission to their son to operate the vehicle and has a horrible crash because they're drunk. Insurance does cover that. And there's some decent insurance in this situation. And that was tendered pretty early. All right. So then that leaves the case continues against the three retail establishments. And our argument as the plaintiff is that they're all responsible, strict liability. Once we've established that he's under 21, under general obligations law 11-101, once we prove that he was served alcohol, there was no dispute he was served at each of these places, also no dispute that he's under 21, here we go. It's a strict liability. So we send all these letters, we do all the depositions, we do discovery. We did find some video at a few of the places, not at all of them. We did get some receipts at a few of the places, not at all of them. So we were able to sort of figure out, and our client told us information. He survived, badly injured, but he told us which bar they went to, and who drank what, who paid for what. So two of the three restaurants based on the case law we provided, our bad faith letters after we did all depositions. We're pretty sure they were dead in the water. And we settled with both of them at a mediation and got a nice result for my client. There was one holdout, though, Hacienda. Hacienda said, you know what? We think that, our bartender says he didn't know your guy was under 21 and he asked for ID, and he always asks for ID, and we'll offer you something, but we're not offering you as much as what you want. So I said, all right, it's strict liability. Let's go. So we move for summary judgment. And what you have in your materials is my oral argument from that summary judgment motion, which I thought was a pretty good oral argument, but it didn't carry the day. I argued what I've just explained to you. I give a nice detailed history to the court of how this is a draconian law meant to penalize. No dispute about it. It puts the burden on the retail establishments. Hey, you don't want to get stuck with this? You better have the proper scanners. You better know how to check IDs. You better do whatever, that's why you go some places and they say, we check ID if you look like you're 30 or under. All of these things are in place. And it's what if I'm representing a retail liquor establishment, I'm telling them, you better have scanners, you better card everybody under 30. You don't want to mess around with this because you could be sued if somebody gets drunk. You've got to be very careful. So here's the argument that the defense brought in. Very good adversary, very good lawyer, John Sokolow on the other side, representing Hacienda. He said, listen, our position is we didn't know. We didn't know that your guy was under 21 when we served him alcohol, and my client did. And I said, well, the knowledge component only applies in general obligations law 11-100. You have to know or have reasonable cause to believe they're underage. But in general obligations law 11-101, it's silent. It's silent about knowledge. It's known to be penal, and it says actually or apparently under 21. I would have bet the farm that we had a lock on this case. I get a decision by Judge Onofre, who basically says no. He says their bartender testified that he saw an ID and was 21. And by the way, when I questioned the bartender, he had no actual recollection. He was, I think he was Mexican, and I don't think he really even knew what to look for in an ID and all that stuff. But his testimony was, I know at the time, I always do it. I checked his ID. He looked 21, and his driver's license said he was 21. And the court held, Judge Onofre, the trial judge held in a decision that he believes there is a knowledge component. Now, here's where, for those of you who like to really get into the weeds on statutory language and sort of geek out on this, here's where you roll up your sleeves. Now, general obligations law 11-100 came in later, came in after 11-101. And there's some cases that talk about the fact that it meant to mirror, and that these statutes were really meant to mirror each other, except one's commercial sale and the other's furnishing. And I yelled as loud as I could to anyone who'd listened to me that, no, there's a reason why it's strict liability on 11-101 and penal. And you don't have to have that knowledge component. So we appeal the case to the Second Department, and you have that decision in your materials. And I was like, oh, we're going to win it now. The Second Department's going to realize you can't conflate the two and impute knowledge into the strict liability statute. It's strict. There's no knowledge required. And the Second Department, stunningly, in my opinion, agreed and rendered a decision that you have in your materials saying that there's no issue of fact. The guy said at Hacienda, I didn't know he was under 21. I had no reason to know. So we're not going to hold them liable. I spoke with my appellate counsel at the time, and we geared up a brief. We went and we saw leave for the Court of Appeals. I said, this is crazy. They're undoing all of this, couple hundred years of jurisprudence. And the Court of Appeals declined to take the case. And I've shepherded my case. I've seen what I can, and still, unless someone sees something different on the books right now, under the law, there appears to be a knowledge component that is imputed into General Obligations Law 11-101. So now if I'm defending these cases, I'm making sure that these bartenders are prepped to say, I had no reason to believe he's under 21. Everybody who comes into our place is over 21. We have signs everywhere. I was shown an ID. That's all I need to do. And and I think at the very least, it creates an issue of fact, and it'll get you out of strict liability. The places that did settle, one of them settled even though they were alleging he had a fake ID, but another place, they didn't card him. And there's no proof they did. And we had a witness say, yeah, you know, they didn't card him, including our own clients that I was sitting right there. They didn't card any of us. So the strongest cases for a plaintiff are going to be the ones where they're underage and you can establish that they were never checked for ID. The harder ones are going to be above age, visibly intoxicated, or underage, where the ID is given. Now, I was in the second department. If anybody has a first department case, I'd love to get involved in it and go up to the appellate division and see what their take on this is, because this might make it ripe for the Court of Appeals if another department looks at it separately. But the case law is really interesting in this area, and it's still not settled as much as everybody thinks that it is settled. So statute of limitations question I want to touch on is 3 years for 11101 or 11-100, and it actually is 3 years even in a death. It's not the 2 years. So check out CPLR 214 subdivision 2. And of course, the EPTL 5-4.1 is what applies to death actions. So you're always going to want to look at that scenario. So when you draft your complaint, I gave you a sample complaint from this case that I've been talking about. It's in the materials. It's a good one to use when you have a driver and one or more facilities. Generally, I would recommend alleging 11-100 as well as 11-101, because if the facts in the case come out that there wasn't an actual sale, you want to have 11-100 as your backup. And you want to make sure you cite that there was an unlawful sale under the Alcohol and Beverage Control Act, Section 65. That needs to be in your complaint. So you want to have specific allegations, specific causes of action for each statute for each location. So if you've got 2 bars that they went to, 2 different ones, you'd have a cause of action against each bar under 11-100 and a cause of action against each bar under 11-101, as well as alleging all of them violated Rule 65. So that's in the complaint. And then when you get into discovery, demand everything and question everyone. I mean, these become extremely fact-based. These cases can be made or destroyed with video footage, as well as from witness testimony. Find out if the injured party, if they're still alive and they're just injured but were present. You really want to deep dive with them, the person who was with them, if they were there and part of it. But most of the time, again, it's going to be an innocent bystander who's going to be hit by a drunk driver. That's usually what happens here. And that makes it tricky to find out where that drunk driver was. So we have our investigators reach out to the police. If they're being prosecuted for DUI, we'll try and reach out to the prosecution, the district attorney's office. Maybe they've done some homework. We know that in the Matt Ferber's case, the state police got involved. They went and took statements from all of the bars because it was a highway fatality. They were drinking. So they did a pretty good workup. It took us about a year to get that discovery through our Freedom of Information request, the FOIL requests to the state police. But investigations are really key here. So it's important you look into that. All right. I am going to start to look at some questions in the few minutes we have remaining, and then we'll carry those over into the last half hour from 2 to 3. I encourage your questions. They're really important, and it's what I'm here for to share with you on how to handle these cases. So I know Josh Bryn asked me a bunch about something unrelated to this. So Josh, just reach out to me, schedule a one-on-one Zoom. Happy to chat with you about that. All right. Jose Gonzalez is asking me, am I talking about voluntary intoxication, right? Yeah, voluntary. I guess the only way it's not voluntary that I would imagine if someone unsuspectingly slipped somebody alcohol when they didn't know it. Um, I don't know of any situations where anybody was forced alcohol. I guess it could be like a college hazing environment if they were forced alcohol and then an accident happened. But I think under that situation, you would just you can go under the 11-100 knew or should have known that they were under 21, but you wouldn't have the visibly drunk part there. So again, these are all fact-based, but usually I've never seen one where it's not a visible intoxication. A voluntary intoxication from that tortfeasor. So keep an eye out for that. All right, Martin is asking me if a bar owner knows a patron is an alcoholic, serves them alcohol, and then that patron assaults other customers, is the bar owner responsible, or is the known alcoholic patron liable? So the answer is both. And we've actually had that case. We had a case where two guys are at a bar and they're drinking, and and they exchange words and one of them goes and grabs and tackles the my client, and my client's foot gets caught in that little ring below the bar stool that you rest your feet on, the footrest, and he snaps his ankle and breaks his ankle. So we brought negligence and dram shop actions against the place. We had witnesses, including my client, say that he was visibly intoxicated and overserved. He was over 21, and that but for them overserving him and knowing he was drunk because he had acted up a little bit earlier, this wouldn't have happened, that they should have kicked him out. That was the negligence. He was rowdy and they also overserved him. But you always have a direct cause of action against the tortfeasor as well. They are jointly and severably liable. Just like in my case, we had the cause of action against the driver, decedent, and his father, and the bars. In the scenario of a patron at a bar assaulting someone else, all you got to show if it's related to the alcohol, that he was drunk, and then you just have to prove that they overserved him when he was visibly intoxicated. Okay, that's how you handle that. Okay, Robert is asking, can't the wrongful death distributees sue for pecuniary damages even if the decedent himself got drunk? No. So if a family's loved one is the one who sat at the bar and got drunk and caused the accident and died, the family doesn't have a cause of action. Okay? They do not have a cause of action for that, unfortunately. All right. Moving right along. John, can you hold the owner of a building used as a deli, which has set up a bar on the premises without a liquor license, when the owner of the building is an out of possession owner? I would believe the answer is yes. So an illegal sale, even though it's not listed in the Alcohol Beverage and Control Act, Rule 6, Section 65, if you don't have a liquor license and you're selling alcohol, then you are selling alcohol illegally. And I would argue that that would be enough. They wouldn't have to be underage or visibly intoxicated. I'm not sure how that plays out, but then you could always bring that under GOL 11-100 and say, even if they didn't have the right to legally sell it and they're not a seller because they don't have a liquor license, then they furnished alcohol, and it would have to be to someone under or apparently under 21 and they have notice of it. So again, it's going to be the facts. And again, based on the state of the law now, there's a knowledge component, at least in the second department. In the first department, I would argue that if someone is an owner of a building, and in that building they sold alcohol, and they sold it to a minor, and they cause accident or injury, there's no knowledge component, in my opinion, except now in the second department. So in the first department, I would make that argument that there is no knowledge component if I'm the plaintiff, and I would say that that they are liable, strictly liable. If I'm in the second department, or if I'm defending that case in the first department, then I would argue he didn't know, or she didn't know as the owner, had no reason to know. They didn't know that people were selling alcohol in their building, and they didn't know there was underage or someone visibly intoxicated. And I think if you can establish that knowledge component, you're good to go. You're good to go, at least in the second department. All right. That's a great question. All right. All right. So Dana's asking for an update. I'll give the update on the ski case at the end after I get through all these questions for those of you who want to hang out and are interested. All right. A kitchen employee of a bar works a 5-hour shift during which he drinks his own vodka. The employer sends him home due to his intoxicated condition. He hit someone a short distance from the bar. All right. So if we were in a big room, I'd ask everybody a show of hands. Is this a good dram shop case or not? And I would hope to see, if you're paying attention, most people saying, yeah, I don't think this is a good dram shop case. You know why? Because he's drinking his own, he's drinking himself. He works at the bar. He's been drinking the whole time and gets in a car and causes an accident. So the owner of the bar is not going to be responsible for that. It's going to be that individual. Now, if the employer, if you can prove that they had knowledge that this person was drunk before they started drinking more, I mean, clearly once they were drunk, they sent them home and said, you can't be here. But I don't think that imputes any liability to them, because the establishment was not serving this person. This person was serving him or herself. And I don't see how you get liability against the owner of the bar under these circumstances, since he wasn't a patron, he wasn't on the receiving end, it wasn't a sale, he was just helping himself. Nobody was furnishing it to him. So unfortunately, as a plaintiff, I don't think that's a good case. And as a defendant, I think that would be a good case. All right, Frank is saying, I suggest you obtain the SLA records. I believe he means the State Liquor Authority records on the business per subpoena. I once discovered the owner had failed to note on his application of a proper criminal conviction. In addition, there may have been prior similar incidents. If they're security guards, you can obtain their names and confirm that they are licensed, properly trained, and if the bar has properly maintained their records. All great ideas. Thank you, Frank. Yeah, you definitely want to find out, did they have a liquor license? Did they get suspended? Have they had other situations? Now, again, that may or may not come into play. One might dispute and debate whether or not not having a liquor license means that they don't fall within the statute. I would say that whether you have a license or not, or whether it's in good stead or not, if you're selling it, you're selling it. But again, you want to get as much information as you can. That's what we do in our discovery to see, to make our cases strong to bring against and prosecute or to defend. Also, many bars will have programs, there's state programs that the bar will bring in and require all the bartenders to go through. They're usually like a 1 or 2 hour program that talks about what we're talking about, the importance of not serving alcohol illegally, making sure that they card people, check IDs, what to look for to determine if someone is visibly intoxicated, slurring their eyes. So there is training, and you always want to make sure to inquire of the bar owner, restaurant owner, whoever's managing the people that are selling the alcohol. What training did you put in place? What steps did you put in place to check IDs? What steps did you put in place to check so that bartenders have some objective criteria to determine if individuals are intoxicated by visibly seeing them? So this is all part of the discovery process. So thank you for that.
If you're joining us today via podcast, the second attendance verification code is SHP224. Again, that's SHP224.
Charles Miner's asking again, what if this is the bartender who got drunk and got sent home? Is there a cause of action against the employer for launching an instrument of harm? You know what? That could be argued. I believe we've looked into these before, and I think it's really hard. I don't think there is a duty that if the employee is off the clock, they're not working at the time, they're told get out of here. I don't think that that owner is obligated to put them in a cab or a car service or make sure someone drives them home. I don't believe that that's their obligation under the law. Although, if you can make that argument that they're required to do it and it would be negligent, it would be foreseeable. So you may not get them under the dram shop, but I would certainly, if the damages are big enough and the case warrants it, I would try it all. I would try dram shop. I would dig in, see what facts you learn, get going with discovery. I would certainly argue negligence. It's foreseeable that this person going home, you sending them home, it's foreseeable they could injure somebody. So I wouldn't give up easily. I'm just saying I don't think it's a strong dram shop case, but I would certainly give it a shot. Statute of limitations we talked about is 3 years. All right, Raymond's asking, what about if the person sneaks in after he's carded and the ID is taken away? Again, my take on it, for what it's worth, and I'd love to test this out of the first department, the second department disagreed with me. The second department under that situation would say, well, he snuck in. You know, we check IDs at the door. We have people who are paid and trained to check IDs. By the time they get into my bar, I know they've been screened and they're not underage. If they snuck in, I would have no reason to know. To the contrary, I assume they were of age. So it's that knowledge requirement that I just don't get why the second department found that and imputed knowledge into this penal strict liability statute, and the Court of Appeals didn't want to take it up. So I'll be very curious for all of my scholars out there. Please keep tracking this in the first department and give it a shot maybe again if you're in the second department. But I think under this fact scenario, the knowledge component is going to make or break a lot of these cases going forward. All right, Robert LaPlante is asking if a person is charged with a DWI, how do you go about getting the police information such as BAC statements given, etc.? So generally, sometimes it'll be in the police report if they take they do a breathalyzer test and they cite them or arrest them. That's in the police report. Sometimes they'll even put the blood alcohol in there. Otherwise, unless you get a HIPAA authorization from the intoxicated person with the identification of where they went, if anywhere, to a hospital to have blood drawn, it's unlikely you're going to get that information. So it's always hard to prove intoxication. But you would definitely do a FOIL request from the police, as well as if the witness of the intoxicated person was prosecuted, you do FOIL requests through both, through the prosecutor's office and through the police department. That's generally how you get it. I believe you'll have prima facie evidence of intoxication if they were arrested for violation of a criminal statute that said that they were intoxicated at the time. I believe that's negligence per se, or evidence of negligence, rather, that you could use in your situation. All right, Stephen. Hey, what's up, my friend? Stephen Krause, excellent defense trial attorney who I've had cases with in the past. Do you use toxicology expert testimony as to the drunk driver's blood alcohol level to impute visible intoxication? Absolutely. So what you would want to do is, if it's one of these situations where they say, he didn't appear drunk to me. And it really comes down to that. If you're talking about visible intoxication, then I would definitely, if you could get a blood alcohol content, definitely get an expert. And they can come in and give studies, and they can talk about that visible signs become apparent once the blood alcohol level gets to 0.8 or 0.9, you would expect to see slurring in the eyes. And then if they can go so far as to say, as based on the fact that we know the intoxicated person blew a .2 whatever, we know they were 3 times the legal limit, and there's no doubt within a reasonable degree of scientific certainty that that person would be slurring, that that person would have improper motor skills. It would be impossible not to notice that. I would definitely use that as a sword or a shield if you're in one of those situations. Great question, Steve. Thanks. All right, Colin, what is the impact if the tortfeasor was under the influence of illegal drugs in addition to being served alcohol? So, as far as being served underage, it doesn't matter. It doesn't matter whether they have anything in their system. I guess the only way that really becomes a factor in these cases um, would be, the illegal, unprescribed drugs. So, like, trying to think of a scenario. It's legal to smoke cannabis in New York and in many other states. So let's say some people go bar hopping and they go to a place and they get drunk, and then they go up and they go to another bar, and when they walk into the bar, they're chatting with the bartender. How you doing? Good. We're just getting the night started. We smoked a joint with our friends outside, but we're ready for our first cocktail, and we're taking it easy with the drinking tonight because we smoke. So let's say that's the scenario, and the bartender sees some red eyes, maybe hears or observes something that may be visible, but then they say, listen, I had no reason to think they're visibly intoxicated. I thought they had just smoked some cannabis. I was just serving them. They said this was their first drink. I served one drink. What do you want from me? So that could be a knowledge component. It could be their interpretation of visible intoxication. So these fact patterns are all going to be really unique, and you need to be creative. I encourage you all, as many of you have done, to Zoom with me, my complimentary 101s. You can get through this QR code, run fact patterns by me. I'm always happy to workshop with you, different theories, strengths, weaknesses. But yeah, if you start adding other drugs into it, it can make it complicated. Sometimes it doesn't make a difference, I guess is the short answer. All right, Kayla, is it possible to have a dram shop case that resulted in something other than a car accident? Let's say someone's observed or served as a minor and leaves the place they were served and commits some other form of negligence. Is it still a dram shop case, or are those restricted to motor vehicle? It is still a dram shop case, Kayla. As you will see in the statutes themselves, they talk about injury to persons, to property. So if they get drunk and crash into your house, you could have a lawsuit if all these other factors uh, are apparent, and you can check all these boxes against the facility or parties that furnished or sold the alcohol for the damage to your house. If it's an assault, as we talked about, if they get someone drunk and that person goes and beats somebody up, then you have a dram shop there. The key is intoxication occurs as a result of an illegal sale or serving someone, procuring them alcohol when you have knowledge to believe they're underage. And as a result of that intoxication, they cause injury or damage to others. Pick your poison of how they do that. There's lots of ways people can cause injury, damage, or death to others, and that will apply under the other sections. All right. Joanne is asking me to address videos. Let me see. I don't know what the earlier question was, but videos are super helpful in general for all of our cases. If you can get a video, that is much better than what a witness is going to say. It's actually seeing what transpired. So again, you always want to request any and all videos showing the entry, all places of ingress, meaning entry, and egress, getting out, exits. You want cameras on all the doors to be provided, all the cameras at every register at the bar, on the bar. Get all those videos. It's going to be really important to try and get those. All right. Let's see. Sorry, folks, trying to catch up. Thank you for all these questions. I'm going to try and get through all of them. All right, if a large fight breaks out in a bar, does the plaintiff need to be able to identify the individual or individuals who actually assaulted them to establish dram shop liability? Great question. I'm loving these questions because it shows all these different fact patterns that we can run into. I think you do need to identify the individuals who caused it, because unless you do that, suppose it's a crowd, and let's say it's four guys are there. One guy's a designated driver, isn't drinking, but he's the boxer, the tough guy. And let's say the rest of the crowd gets drunk and someone picks a fight with somebody. They all start fighting, and it's the sober guy who knocks the guy out and breaks his jaw. Um, they're not going to have any liability if it's the sober guy who did it. So you have to establish who did it, who caused the injury, and that individual, the tortfeasor, was the one who was intoxicated and wrongfully sold or furnished alcohol. All right, Marcus, what about liability for a club or lounge for bottle service? Patrons order the bottle of tequila. The club lounge has no control over consumption. Patron then causes harm to others. Great question. What do you all think? I think that, again, you have to apply the law, the facts, and I think in the second department, a lot of these clubs and lounges are going to be off the hook. I gave the bottle to this guy. He's 50 years old. Smiley, I gave it to him. He's a lawyer. He teaches this stuff. I wouldn't think, I'd have no reason to believe he's going to get his daughter and all of her friends who are underage hammered who are dancing at the club. I think they're off the hook. But I think if it's in the first department or another place outside of the second department, and they knew or should have known, they didn't check IDs, they're serving alcohol in the presence on the premises, young people are there under 21, they're letting young people in there with the knowledge that it's bottle service, it's foreseeable. I would make that argument that if they're not checking IDs, then they knew or should have known that they would have underage people with access to alcohol, that they can't shield themselves from liability by making it easier and just handing over the bottle to somebody who pays for it. So again, a lot of this is going to be researching cases to find similar fact patterns to yours. And if you can't find similar fact patterns, you're going to have to apply these statutes, 11101, 11100, Section 65, the case law, to your fact pattern, and do what we do as lawyers and be an advocate, argue for or against it. All right. Host of an adult party where drinks are served, all over 21. So the first question is, can a host of an adult party where everyone's over 21 be held responsible under these dram shop laws? So I invite 3 couples over. We're all north of 50 years old. Everyone's drinking. One of my friends gets hammered and decides, I'm good. I'm going to drive home. I beg and plead. No, give me your keys. No, I'm good. I'll send you home in an Uber. No, I'm good. They get in a car. They go home and they injure somebody. I will not be liable. I will not be liable because I've not illegally sold alcohol. So that gets me out of GOL 11-101 and Section 65. I haven't sold any alcohol, and I'm out of 11-100 because I haven't furnished alcohol to someone who's under 21. Don't forget, 11-100 doesn't apply to the habitual drunkard or visibly intoxicated person. It just talks about someone under the age of 21. So in a private setting, if no one's under 21, you've got nothing to worry about. In a private setting, if someone's under 21 and you knew or should have known that they were drinking and getting intoxicated and under 21, that's when you have an issue. What about other intoxicants? Drugs, roofies? Is it only alcohol? Yeah, so these statutes are alcohol based. All right. Intoxication. My understanding is that intoxication, that phrase, refers to alcohol, and especially since we're talking about these statutes are based on Section 65 of the Alcohol Beverage and Control Act. So certainly under 11-101, you're going to have to show that it's alcohol. It's not other drugs. These statutes we're talking about are alcohol only. All right. Martin, if a bar owner knows a patron is an alcoholic, serves them alcohol, and then that patron assaults other customers, is the bar owner responsible, or is the known alcoholic patron liable? I don't know if I answered this, but yes, that would be the habitual drunkard, is the alcoholic. Now, I'm assuming if you can prove as a matter of law, as an undisputed fact, that this person is an alcoholic, I would imagine that that's equated to habitual drunkard. Maybe you can be an alcoholic and not be a habitual drunkard. I don't know if that's possible. It takes some creative lawyering to argue that, but yes, if they knowingly serve an alcoholic and that alcoholic injures somebody else, then the establishment is going to be liable if you can prove it, as well as the alcoholic is going to be liable as well. All right, Ashley, my position, referring to me, is my position that an underage or not who contributed somehow to the procurement of the alcohol has no recourse. Is that right? Yes. So if I'm 19, I show a fake ID or not, I get into the bar and I pay for the drinks, then I get drunk and go cause an accident. Then and I'm injured, I cannot recover for my injury. Again, the issue as far as procurement is whether the injured party can recover. So the injured party, think about it, has to have clean hands. The injured party couldn't have been part of this. And that was one of our concerns, because our client who lost his leg, Matt, he was at the bar with the tortfeasor. This wasn't a stranger that caused this accident. This was a colleague of his. They were all at the bars together. And we were very concerned about the fact, Matt, did you pay for any of these drinks? Because if you paid for any of these drinks, you're not going to have a case under the dram shop because you were part of procuring the alcohol for the person that injured you. Okay. So, picture you and your friend who likes to drink. You go to a bar. You're just keeping your friend company. Your friend has a couple of drinks, gets drunk, gets in a car, causes an accident. You're injured. You got to be careful. Did you buy any of the drinks? Did you give a tip to the bartender? Did you, facilitate and say, hey, this drink's on me. I'm buying you a drink, even though I don't drink. So you have to have clean hands. You cannot spend or do anything that would be deemed as procuring alcohol to the tortfeasor. That could be added into their intoxication levels. Okay. So yes, that's how it works. All right. All right. Ashley's confused in my response. An employer sending a drunk employee home would not have liability. What if they injured someone else driving home? So again, as I said, it's going to be fact-based. But if you can show that they weren't on the clock, they weren't working for you at the time, you didn't serve them alcohol, you didn't sell them alcohol, they're not underage, and you said, you're fired, get the hell out of here. You've been drinking on the job all night. I do not believe that there is liability for that. I do not. If there's a case out there that I'm wrong, then tell me, and I'll be happy to be proven wrong. I'm not right about everything, for sure. So, but yes, under the laws I know it, they would not have a legal obligation. The guy or gal who's drunk who goes home would have. Again, it doesn't give them a free pass that they're drunk and driving and cause it. They're still obligated. They can still be sued, but you can't get that additional liability coverage, the liquor liability coverage under that. All right. Now I'm being asked, what about a landlord of college housing who knows his tenants are throwing wild parties? Assume none of the tenants have insurance. And what is injuries as an assault? So again, the injury can be an assault. Again, folks, you're going to have to apply the fact pattern here. So if you own a house, right, and there are college parties there, all right, you're not going to be liable unless you knew that there was underage drinking going on or should have known and you didn't stop it. So if I'm renting a house that's a rental income place to 4 college students who go to NYU, all right, even though it'd probably be an apartment or whatever, and those students invite friends over, they're all underage, they get drunk and someone causes an accident, I'm not going to be liable. I don't have an obligation to monitor that. It's not a sale. I didn't know anybody was under 21. I had nothing to do with it. So you don't have to worry about that situation. All right. Now, if the landlord is there partying with all the kids and has reason to believe they're under 21, that's another story. So when you look into these scenarios of these house parties, are the owners there or are they not there? What did they know about the party? What did they know about the age of the people that were there? What did they know about whether drinking was going to happen? These are the things you're going to have to find out when you do your investigation and your depositions. Okay. All right, John is disagreeing with me that an out-of-possession owner would be liable for the acts of someone else illegally selling alcoholic beverages. The out-of-possession owner is not the actor. Maybe you have an argument if the owner knew of this illegal activity and permitted it, but absent that, I see no case. Well, I know, John, the Second Circuit would agree with you because there's no knowledge, and the Second Circuit says there has to be a knowledge component. So if there's no knowledge, that's it. Now, whether or not they are allowing an actual sale from it, if they have no knowledge that someone's selling alcohol from their premise at all, and it's not even reasonable to think, and it's an illegal sale, and it's, a house, and they're not, it's going to be fact-based. Again, I think it's going to come down to a knowledge test as well. It's not absolute liability. So if I said that, if it's a private home and you're out of possession, or if it's a gym, let's say you own a gym and that gym decides to hold an event for its clients and it sells alcohol and there's an illegal sale, then you're probably right. They're probably not going to be held accountable. But if they rent it out to a restaurant where they know and they don't have any agreements about whether or not they can sell it or not, sell alcohol, and what has to be complied with, what their knowledge is. So again, I'd really look at the knowledge component on that, John. All right, Christian. The appellate division is a single statewide court divided into departments for administrative convenience, and therefore the doctrine of stare decisis requires trial courts in this department to follow precedents set by the appellate division of other departments. So general principle of appellate procedure, and Christian is citing Mountain View Coach Line, Second Department, 1984. I hear you. And I know we're citing in our cases all different appellate divisions, and they all should speak with one voice. I also happen to know through my 30 years of experience that sometimes departments come down differently on similar fact patterns. You see it a lot in the labor law cases. You see with different fact patterns, and that you can have departments disagreeing with each other. That's when cases will become more ripe for the Court of Appeals. So as a general rule, yeah, the departments should follow each other, of course. All right. Colin, if a tortfeasor commits an intentional assault, there's reason to believe the tortfeasor intended to assault the victim prior to being served alcohol. Can the victim's injury still be by the reason of the tortfeasor's intoxication under the dram shop? That is a great fact pattern. So let's assume I'm mad. I'm mad at Phil. And I know Phil's going to be at this bowling alley tonight, and I'm really mad because he did something that's got me all worked up, and I may just want to go punch him in the face. And I'm planning on it, and evidence comes out that I was mad, that we had words, and I said, I'll see you tonight at the bowling alley. We're going to take care of it. And I show up at the bowling alley, and then I get drunk. And then I take care of it, and we get into the fight. And then if you're defending them, you're saying, look, he was going to punch him in the face no matter what. You have this, right? You have this in the record. It's not from the intoxication. Andrew was angry anyway. Well, the first thing I would do in that fact pattern is I would see if the facility violated the dram shop. Did I appear intoxicated and did they overserve me? Am I underage and they illegally sold it to me? That's the first step. If you think you have that, then I would go to Steve's question about bringing in an expert and saying that, listen, studies show that intoxication reduces inhibitions. There's no reason to believe that this guy wasn't just talking Andrew wasn't just spouting out. He was saying, yeah, you're going to get yours, but wasn't really going to do anything. It wasn't but for that liquid courage we hear about, getting drunk, and they did it. They gave him the weapon. They gave him the juice, the alcohol to get him all fired up. So I think you could argue it both ways, bring an expert and see how it plays out. But that's a great potential fact pattern. Kayla, since the driver in my case died, did anyone check to see if the police recovered a fake ID on his person or in the car? Great question. The answer is yes. They did recover a fake ID. They did recover a fake ID. But the question, we have some people saying he didn't use it. They never saw him pull it out. Apparently wasn't a very good fake ID. So yes, that was an issue that we brought out, and we made it a point to get it, to compare birth dates to his real date, to figure whatever we could out. So that's another fact that you would look into. All right. Jose suggesting if someone's arrested, you wait for a guilty plea, or if they get convicted, that there's a prima facie case. If they admit that they were intoxicated, absolutely. We actually just settled a construction accident case where a roofer fell off a roof. He wasn't given any fall protection, and the owner of the roofing company that employed him pled guilty to involuntary manslaughter. This had happened before. The U.S. Attorney's Office prosecuted him, and he was on the record saying he knew they were up there. He knew that he didn't give them fall protection. He knew he was supposed to, and he allocated to that on the record. And we settled the case before depositions. So it's always good to get a guilty plea in your civil cases. All right. Michael, thank you for the compliment. He's saying, Andrew, the police investigation report may redact the BAC, the blood alcohol info. If the defendant testifies at the EBT, they went to the hospital, blood taken. What's defense opposition to motion for a demand for a HIPAA for the blood alcohol? Great question. I would think that you'd be entitled to demand a HIPAA for that. They've put their, you could even agree to let them get it first, redact it, redact the whole chart, and just send me the blood alcohol result. If you're worried about anything else, you may have to engage in motion practice. But I think if you can establish, my argument, Michael, would be motion to compel the disclosure. And my argument would be this is vital information. I would cite that the burden of proof under the law is showing that they were intoxicated. We have reason to believe they are. And the only evidence of it would be in the hospital report. We're willing to have it redacted and just provide us with the result. And I don't see why a judge would not grant you that, but I would certainly go for it that way. Joanne is asking me about retention time for videos. So like in any other place, I mean, the general school of thought is most places that video things, even home videos, business videos, bar videos, it's usually like a 30-day, and then it's taped over. That's just been my experience. There's no set rule of how long someone's supposed to keep video or not. That's why you need to send a preservation letter out immediately. So even if you're not getting the video, you're putting them on notice that you want it. And if they're not going to give it to you, at the very least, preserve it. They're on notice, and so on and so forth. All right, we are at 2:30. I really appreciate all of these questions. My closing thought is get as many facts as possible. Find out as much as you can now that you know the law, and then look and see if you got it or not. Or if it's a close call, go for it. You have to make these decisions that we all do as lawyers, and I'm always happy to workshop it with you. So if I didn't get to your question, sorry we ran out of time. Please email me. My information's behind me, and I'll do my best to get you an answer or book a Zoom with me, and we can chat about it. Great to see you all. Hope you're all having a great summer, and I'll see you on July 9th to wish you a better summer ahead from that point.